one party against another, as that are done by one party against another. As a result of the wrongdoing, the injured person may take civil action against the other party. To simplify this, let's say while walking down the aisle of a grocery store, you slip on a banana that had fallen from a shelf. You become the plaintiff or injured party, and the grocery store is considered the tortfeasor or defendant, the negligent party. Simply said, you would probably take civil action against the grocery store to recoup compensation for pain, suffering, medical bills, and expenses incurred as a result of the fall. Negligence is just one tort category. There are three general categories of torts. Regardless of the tort action, three elements must be present. Tortfeasor or defendant had a duty to act or behave in a certain way. Plaintiff must prove that the behavior demonstrated by the tortfeasor did not conform to the duty owed to the plaintiff, and the plaintiff suffered an injury or loss as a result. Because torts are a civil action involving private parties, punishment does not include a fine or incarceration. The punishment for tortious acts usually involves restoring the injured party monetarily. Sometimes a court order may force the tortfeasor to either do or not do something. Think trespassing, defamation, or slander. Let's explore three types of torts: intentional torts, negligence torts, strict liability torts. An intentional tort is an act that is intentionally committed against another person with the aim of causing harm. There are several intentional torts that fall into this category, like assault, battery, conversion, fraud, false imprisonment, trespassing, and invasion of privacy. Not every injury-producing action is cause for an intentional tort lawsuit. The court will look at the conduct of the defendant to determine whether the actions were, in fact, intentional or just mere willful and wanton behavior, not specifically meant to cause fear or injury, but is considered reckless. Betty Geeslin, a personal representative of Bill Geeslin in Bill Geeslin versus Kobe Bryant, is one of those cases. Back in November of 2005, Geeslin and a friend attended a Lakers-Grizzlies game. The fans held courtside seats for the event. At some point during the game, famous basketball player Bryant ran to retrieve an out-of-bounds ball. As he reached for the ball, he lost his footing and fell atop Geeslin, leaving him with injury to his chest and lungs. After several days, Geeslin, now home, began experiencing uncomfortable pain in his chest, severe enough to visit an emergency room. Once examined, it was diagnosed that he suffered a bruising and a crushed lung. He was prescribed several pain medications and a breathing machine and sent home. After a few weeks of home treatment, Geeslin decided to sue Bryant for assault, battery, and infliction of emotional distress. Geeslin claimed that when Kobe attempted to remove himself from Geeslin's chest, he used extreme force to push away, causing injury. Geeslin also claimed that he could no longer sleep at night, suffered anxiety, and felt embarrassed by the incident in general. When the court analyzed the case, it felt that the elements for tortious behavior were not present. Specifically, Geeslin assumed the risk of injury by choosing courtside seats. Bryant in no way intended to cause injury to Geeslin at the time of the initial fall or as he attempted to return to the court, and a reasonable person would not conclude that the incident was so seriously traumatic that Geeslin suffered emotional distress to the degree he claimed. In a motion for defendant's summary judgment, the court ruled in favor of Bryant. On a side note, Geeslin died prior to final judgment, and a personal representative maintained the claim against Bryant until time of final judgment. However, Bryant settled with the estate out of court for the sum of $75,000 to put a rest to any further appeals or complaints against him. Our next tort deals with actions that cause injury that do not have intentional characteristics. Negligence occurs when a party fails to demonstrate the kind of care a prudent person would take in the same situation, and an injury results from the action or inaction. There are 5 elements necessary to prove a negligence case. Defendant owed a... There are instances when a person becomes responsible for things that may go wrong, even if the person did not intend for the wrong to occur. In other words, some actions hold a person strictly liable regardless of the circumstances. Say you owned an exotic python. If the snake creeps out of the house and bites your neighbor, you will be held responsible even though you did not let the snake out. Ownership is enough to hold you responsible. In other words, strict liability tort means a defendant is held fully liable for any injury sustained by another party, regardless of whether the injury was intended. Dangerous animals are just one of 3 major strict liability categories. Strict liability categories include animals owned or possessed, abnormally dangerous acts, and product liability. The owner or person in possession of certain types of animals is liable for injuries if the animal causes injury to another person or animal. This may include livestock like cows, horses, bulls, or goats. Abnormally dangerous animals also fall under this category and may include snakes, tigers, monkeys, or bears. You may think wild animals are not included because, well, they live in the wild, but that is not true. If a person is in possession of a wild animal or has wild animals on their land, like animals that are housed at a zoo, and the animal causes injury, liability is assumed. Livestock and domestic animal ownership is fairly easy to prove. Livestock is generally branded, and domestic animals require registration in their place of residence. Wild animals, on the other hand, are more difficult to track. An interesting case that remains in litigation as of late summer of 2013, the question of possession and ownership of suspect wild animals remains unanswered. Arizona's Sonora Desert Museum is located in a remote area of Tucson, Pima County. It is a place where tourists can experience Arizona's indigenous landscape. Back in 2009, a Dutch tourist and plaintiff, Zegeris, was brutally attacked by a wild javelina while touring the grounds. The victim sustained extensive damage, including torn muscles and severed veins and arteries to his calf and hand. So much damage was done that he was hospitalized for over a week. As a side note, javelinas are although they are not particularly aggressive, attack if cornered. Javelinas were commonly seen on the trails within the museum. Although the museum did not own the animals, they were part of the scenery in a wildlife attraction. The question remained, who was in possession of this peccary? This is where it gets a little muddy. The museum operators claim that this particular javelina was not one of the commonly seen animals on their property. They performed blood tests on the javelina in their possession, and it turned out that no match could be determined. In fact, the javelina that attacked Zegeris was never found, but the looming question of strict liability was still left unanswered. At last report, the plaintiff's attorney filed further action claiming that regardless of the ownership, possession is all the law requires. Javelinas are wild animals. No provisions were made to corral the owned javelinas. Therefore, other javelinas can come and go freely across the boundaries. While, as of late summer of 2013, no verdict had been rendered yet, this case proves that strict liability may be applied to cases where ownership does not have to be established. Another form of strict liability comes with engaging in abnormally dangerous acts. An abnormally dangerous act can be defined as an act that carries a substantial risk to oneself and others' personal property and physical being. That's plenty of legal mumbo-jumbo. Think pyrotechnics, nuclear power plants, and blasting rocks with dynamite. In Miller versus Civil Constructors Incorporated, a bullet fired. Your hairstylist suggests that you need a new look. Excited about the possibilities, you consent to allow her to use a new brand of hair color. After several minutes under the dryer, you smell a strong odor. Yikes! The smell is coming from your hair. The new treatment caused your hair to burn at the roots. Your hairdresser never read the warning on the package. It states that the product was not to be used with heat. Left with your curly locks lying on the salon floor, you cry foul play. Well, it wasn't exactly that. It was negligence. You see, your hairstylist's actions were less than the expected standard of behavior by a person, and the actions caused damage. In order to prove negligence, the court will look at the elements: the defendant's duty to the plaintiff, the breach of that duty, a cause in fact, proximate cause, and damages. Let's break each element down for better understanding. Duty refers to one person's obligation to another to act in responsible ways. The hairstylist should have read the instructions and warnings prior to applying the product to your hair. Where there is a breach of duty, it simply means that the defendant did not act in a responsible way, and the actions do not have to be intentional. It could be an oversight, a mistake. A cause in fact is established when a connection between the defendant's actions and the plaintiff's loss is established. Under normal conditions, your hair would not burn under a standard hairdryer. If not for the treatment, you would have not suffered damages. Different than cause in fact, proximate cause is the direct cause for injury. It does not have to be the closest act in time, it just has to be the most significant act. Think of it as the scope of liability. Just how responsible was the hairstylist in causing the damages? To say it a different way, cause in fact is the connection between the negligent party's actions and the loss. In that instance, not reading the warning label proved to be neglectful. Proximate cause is the actual act of placing the product on your head was really the initial act that caused the chain of events that caused you to lose your hair. The but-for test may help to explain this. Think of this as if the action did not occur, then the injury would not have. That establishes a causal relationship. Had the hairdresser read the label, she would have known not to use a dryer in conjunction with the treatment. Had she not used the dryer with the treatment, your hair wouldn't have burned. That is the chain of events that demonstrate proximate cause. Damages are restitution for the loss suffered by the plaintiff. In some cases, it may be money as compensation for a loss. In other cases, it may include money for pain and suffering, loss of enjoyment of life, or even future wages. In a case involving fireworks, an explosion, and an injured passenger, let's see how the law applied the elements of negligence to reveal a very interesting outcome. There are a few twists in this case, so follow closely. The plaintiff, PALSGRAF, taken by a defendant that causes foreseeable danger or injury to another, like intentionally throwing a banana peel on the floor of the office cafeteria. Someone is bound to slip and fall. The elements are pretty simple. The defendant had a duty to the injured party. The defendant failed to act on his duty. The negligent act caused direct injury, and the injury should have been reasonably foreseen. Once the elements have been satisfied, a defendant can be held liable for injuries sustained by the plaintiff. But is every injury sustained at the hands of another party a cause for a negligence lawsuit? Maybe the banana peel tossing pest doesn't have a very good aim. Should he be held fully liable if a coworker slips? Well, maybe. But not every action is cause for litigation. There are several defenses that can be used to reduce a defendant's liability or shift a portion of the liability onto the plaintiff. You had a few too many cocktails during happy hour, but somehow you remembered to stop off at the market to pick up cat food. On your way down the pet food aisle, you trip, slip, and slide your bottom from one end of the store to the other. Ouch! When help arrives, it was witnessed that no slip hazard existed. No spills, no sticky stuff, nothing. But everything from your bum to your ego is sore and you want justice. Well, not so fast. The law may see it a different way. Although mostly abolished by the courts in modern times, contributory negligence may save the market from a costly lawsuit. This defense holds the plaintiff responsible for their injury if the plaintiff was in any way responsible for it. even if the defendant was more responsible for the injury than the plaintiff. In other words, if you arrived at the market after a night of heavy drinking, that may have been the contributing cause for your fall. Had you not been drinking, it is possible, even probable, that you would have remained upright. The more recognized defense is comparative negligence. In this defense, the court will apply a percentage of negligence to both parties depending on the degree of responsibility each has towards the injury. So, in the case of the grocery store spill, the court will want to know a few things. How much alcohol did the plaintiff consume prior to shopping? What type of shoes was the plaintiff wearing at the time of the fall? Was the floor clean and dry at moments prior to the fall? Was the fall foreseeable? There are three categories of comparative negligence: pure, modified, and slight gross. Pure comparative negligence awards the plaintiff damages based on the percentage the defendant is responsible for the injury. Let's say you ordered a hot bowl of soup at a restaurant. When the server arrives, he warns you that the contents may be hot and to be careful when eating the soup. If you dive right in and take a big spoonful and burn your tongue, the restaurant is not liable for the burn. You were warned about the soup's temperature prior to consuming it. Now, had the waiter failed to warn you that the soup may be hot, you may just have a case. In modified comparative negligence, the plaintiff's negligence must be equal to or less than the defendant's negligence. A good example in negligence cases, the court weighs whether a person acted in ways less than a reasonable person would act, like neglecting to shovel snow after a storm that makes for a slippery walking surface. This is sometimes called the reasonable person's test, and it simply measures an act against what a reasonable person would do. There are several defenses available to the defendant for those type of negligence acts. However, in some cases, special negligence defenses can be used to protect a defendant against allegations of negligence. These defenses are negligence per se and res ipsa loquitur. Negligence per se involves negligent acts that violate a public policy, like speed limits or other statutes that protect citizens. What makes this type of negligence different from ordinary negligence is that the court measures the defendant's actions against the policy, not that of a reasonable person. Four elements that make for a case are: the defendant acted in a less than dutiful way, their violation was of public policy, the creation of the public policy was to prevent the type of injury sustained by the plaintiff, and the plaintiff was a member of the group protected by the policy. Let's put this to the test. Sometime in 1889, Miss Osborne did some shopping at McMaster's drugstore. One specific item she purchased was an unlabeled bottle. Not knowing what was in the bottle, she drank it and died. It was poison. Her estate claimed that McMaster's had a duty to label their products. In fact, public policy required product labeling. The clerk in charge of labeling products neglected to do so. Because of his negligence, Osborne was poisoned. In this case, the defendant had a duty to adhere to public policy that required him to label products. He did not do so. When used, this policy will avoid this type of injury, and Osborne was part of the group protected by the public policy. She was a consumer. Judgment favored the plaintiff. McMaster's appealed the decision but lost. The court decided that McMaster's had a duty to label products, and because he failed that duty, a serious injury, well, death, actually occurred. Res ipsa loquitur works a little differently. Res ipsa loquitur translates to the thing that speaks for itself, and means a defendant is considered liable for injury if he controlled the very thing that caused the injury. Imagine the horror of returning home from a hard day's work only to find a stranger sitting on your comfy patio chair, reading your favorite magazine while sipping on a freshly made glass of lemonade. When you ask this person to leave, they refuse. Hopefully, this will never happen to you. But if it does, know that this action, in the eyes of the law, is an intentional tort of trespass to land and involves three important elements. The person entered your property without permission. Person has no legal right to be there and the person refuses to vacate. In order to prove this, one must demonstrate that there was intent or purposeful action to enter and remain on the premises. In our example, it wouldn't be difficult to show that the lemonade-swigging stranger intended to be in your backyard because it is your backyard, not theirs. You did not invite the person, nor did you request that the person remain in your chair. Now, to put a twist on it, what if this person unwittingly walked into your yard, sat down, picked up a magazine, and relaxed, thinking all along it was their friend's home? Well, if the stranger looked as shocked as you did when you both discovered each other's presence, immediately apologized, and ran off of your property, it was probably not trespass. You see, trespass requires that a person be in possession of the land. When a person takes intentional possession of one's personal property, it is called trespass to chattel. Going back to our example, trespass to chattel means that a person intended to possess and use personal property, not real estate, like your magazine and your lemonade. So, if the person ran off and took your stuff, this may qualify as intentional trespass to chattel. Conversion is different. It requires intentional interference and damage. All set out for an afternoon of boating, you drive to the marina only to find that your boat is missing. The police did a bit of investigating, and turns out that your boat was stolen and had considerable damage to the hull. What actually happened was conversion. This means illegal possession or use of another's property, passing it off as his own property, whether intentional or otherwise. In other words, it is a fancy word for stealing. Check it out. The definition states that the possession or use can either be intentional or unintentional. Simply put, it doesn't much matter whether the person who stole your boat meant to outright steal it, or he thought it was just his own boat. Simply taking it is enough to prove conversion, and this person would have to pay for the damages or loss of the boat based on its value. Conversion can be tricky. Suppose you found a great deal on a used cell phone from one of those free online classified advertisement websites. It's the perfect phone at the right price. After much negotiation, you settle on a price and a place to make the purchase. About a month later, the police come knocking at your door and demand the phone, and suddenly you are cuffed and taken downtown for questioning. What just happened, you ask? Here's what may have happened. If the phone you legitimately purchased was previously stolen and sold to you by the culprit, you were in possession of stolen property. Even though you did not steal the phone, you are in fact in possession of it, and that is conversion. Nuisance is another instance of interference with another person's enjoyment of land, and it involves both. To start your day, you run into the local diner to grab a cup of coffee and a donut. When the waitress arrives to pour your coffee, you notice that she is a bit wobbly on her feet. You also notice she is wearing a medical alert bracelet, but don't pay much attention to it. She pours the steaming hot coffee in your cup, on the table, and even your lap. After letting out a loud yelp, it becomes painfully obvious that you require medical attention to treat your first-degree burns. This means you will be out of work, unable to wear pants, and need costly follow-up care. You think, someone must pay for this action. The waitress was unable to perform her job due to what could have been a medical condition. And you were correct. Well, sort of. Someone must pay, but it is the employer that will bear the brunt of this waitress's actions. You see, the doctrine of vicarious liability holds that there can be a person responsible for the actions of another because of a special relationship the parties maintain, like employee-employer and parent-child. At one time, the courts held that a husband may be responsible for the actions of his wife. This contention has long been abandoned. Let's explore the employee-employer relationship for a moment. When an employee causes injury or damages to another party during the course of his employment, the employer may become the responsible party. This is all because of the doctrine respondeat superior. In Latin, this translates to let the master answer, and in modern times means the employer is responsible for the actions of his employees if the actions cause injury to a party to which the employee owes a duty of care. In order for a court to determine whether an employee acted within the scope of employment, the court will look at a few things. The act or action occurred while the employee was at the workplace and within the hours of the employee's schedule. The employer must have employed the employee at the time of the incident. In other words, employee had a reason to be at work at the time. And the injury was a result of the act or actions of the employee in the capacity that the employee was hired. A waitress is hired to serve coffee, amongst other things. The criteria are important in determining the level of responsibility the employer has to such acts or actions. In this case, the waitress may have been ill while at work. This may have contributed to her spilling the coffee. Let's look at a case involving a fight between an employee and a shopkeeper. Ronell Lynch, a Nabisco Biscuit Company salesperson, was hired in March of 1969 to deliver and stock bakery products on store shelves. Given his own territory, Lynch made stops at local stores to replenish previously delivered products for consumer purchase. Sometime on May 1st, 1969, Lynch arrived at Lange's store to stock the shelves, but noticed that the prime shelf space was not available. After exchanging words with Lange over the use of specific shelves, Lynch violently assaulted Lange. On his way out of the store, Lynch even threw products on the floor. Lange subsequently sued Nabisco Biscuit Company for damages he suffered at the hands of their employee and won. The simple test proved that Lynch was working for Nabisco, making him an agent or representative of the company at the time. During that time, he violated the A pretty brunette sits alone at the bar. A lonely gentleman approaches her and asks, "What brings you here, lovely lady?" Before the woman could utter a word, the man is picked up by his shirt collar and sent sliding across the bar. Sounds like the making of a crime story. Well, it is, sort of, anyway. The woman's jealous husband, angry over the flirtation, committed battery upon an innocent man. Battery occurs when one person inflicts physical harm on another. There are several elements that need be present to prove battery. An act by a person or defendant inflicting harm. There was intent to cause harm to the other individual or plaintiff. Harmful or offensive conduct occurred as a result. Let's break down each element for better understanding. The act itself may come in one of two forms of contact. Actual physical harm that causes injury, like throwing a person across a room, or where the contact is not so much physical, but is insulting. Suppose the pretty woman threw her drink in the stranger's face. That can be construed as battery. While no physical harm was actually done, except to the suitor's ego, the act remains offensive and insulting. Intent means that the defendant meant to commit the act, and can either be specific or general in nature. When intent is specific, the defendant performed an act that he knew would cause injury, like punching someone in the gut. Whereas general intent broadens the element to mean that the defendant is aware that his actions will result in something happening. The outcome itself may not have been intended. This is worth explaining. An impish high schooler sneaked behind the desk of his mean-spirited English teacher and sat a sharp tack on her chair. When the teacher sat on the pushpin, she jumped from her seat. This set off a chain of events that ended with the teacher on the floor with several broken ribs. The student did not set out to specifically break his teacher's ribs, but he intentionally placed a tack in the chair knowing that something would happen. This hilarious prank is battery. The final element of battery is harmful or offensive conduct against another person, and the conduct does not even have to be direct with the plaintiff. We know that committing an act like pushing another person is battery. However, did you know that even if the act was not meant to cause harm, yet did, it is still considered battery? To prove this, suppose a beach lifeguard notices a school of ferocious people have a fear of spiders or arachnophobia. In fact, about 30% of people bug out when they see an 8-legged terrorist. Okay, placing a spider in the desk drawer of an arachnophobic may seem like a funny prank, But if it causes the victim severe panic, you just may be liable for emotional distress. In fact, intentional infliction of emotional distress can be described as an intentional act performed by a defendant that is so reckless that it causes emotional distress to the victim. The court will look at a few things. The conduct of the defendant was outrageous. The conduct was reckless and intentional. A causal relationship must exist, and emotional stress resulted from the actions. Perhaps a case analysis will help to map out the elements. In Rothwell versus 9 Mile Falls School District 2009, Rothwell served as a custodian for a local Washington State high school. When she arrived to work in April of 2009, the principal requested that she clean up the main entrance area. This would have been a routine job, except on this day, a student had shot himself. What made matters worse, Rothwell knew the student personally. For the sake of brevity, we will focus only on the arduous task at hand. Rothwell was summoned to clean up a crime scene to which she had a relationship with the victim. This task included cleaning blood, shattered bone fragments, and brain matter. There were also things the emergency crew left behind, like needles and plastic gloves. Distraught over the suicide and the cleanup, Rothwell was sent home for a few hours. She returned to clean for several hours. She was told by her principal to make the area look as if nothing happened. As the days pressed on, the community set up a makeshift memorial with candles and other things to commemorate the student's death. She was requested to remove and dump everything placed at the shrine each night. Over several days, Rothwell began to experience post-traumatic stress syndrome. This is generally severe stress caused by experiencing something terrifying. Rothwell sued her employer in state court. The court
lost in the woods of tort liability for school personnel. In the quest to find our way out, let's look at the legalities of constitutional torts 42 U.S.C. 1983. This states how, as educators, we have no qualified immunity if we do not conform with well-established legal precedents and violate constitutional rights. Yet, as educators, we still have qualified immunity, which basically protects us from paying damages for acts that violate another's civil or statutory rights. A two-pronged test is used to determine if you get qualified immunity. 1. Was the law clearly established? 2. Could a reasonable officer believe the conduct was lawful? Excuse me for a second, but I'm really lost here. Let me make a quick call. Hello? This is Dr. Dively. I need somebody to pick me up. Excuse me? Sigh. Yes, I'll hold. Great. I got disconnected. Anyhow, like I was saying, because of the Illinois Tort Immunity Act, educators can only be held liable for willful and wanton misconduct. Willful and wanton is defined as actions that shows actual or deliberate intention to cause harm, or indifference to or conscious disregard for the safety of others or their property. Willful and wanton is defined here as negligence, and negligence is a failure to use such care as a reasonably prudent and careful person would use under similar circumstances. Most of the time, the school must pay for your defense, but not if the transgression is considered willful and wanton. If so, you're on your own. As I've stated before in class, anybody with 50 bucks and access to the local courthouse can, and will, sue you. Successfully, on the other hand, is up to you. Well, I'll go this way, I guess. Wish me luck.
No. There's an app for that.
Wow. That was a close one. I really got turned around. Now, where was I? Oh yeah, one more thing you should remember about the Illinois Tort Immunity Act is that we are in loco parentis with our students. This means that teachers acting in place of the parent cannot be held liable for negligence. Just something to keep in mind. Woo-wee, I'm famished. See you inside.
There are generally three categories of circumstances that lead to teacher or school district liability. And so we're going to talk about each of these in more specific detail, but the three categories are those activities tied to teacher activity, those accidents that occur because the teacher did or did not do something. That is, they didn't properly supervise their students, they didn't provide instruction to their students, or they didn't maintain the equipment that the students were going to use properly. The second category of circumstances that arise and cause teacher liability are those related to the conditions of the premises. They may have nothing to do with the teacher themselves, but these accidents occur because the equipment wasn't stored properly or chemicals weren't secured properly. The second type of condition that may exist is that the labeling, containment, or storage of dangerous chemicals on the premises was not done properly. The third category is building design or in the absence of safety devices. So you go into a lab and it doesn't have a shower, it doesn't have eye wash stations. And then the last is overcrowded conditions or inappropriate facility for use. A good example of this is where chemistry is being taught in a math classroom. So these are all conditions of the premises themselves, and they're not directly related to anything the teacher does or does not do. And the last category of circumstances where teacher liability will occur is where there's a violation of a statute or other rule, such as a district regulation, and the teacher fails to comply with the regulation or the statute that governs their behavior. So again, three categories of circumstances.
Teacher liability. I want to start by reading a story. A senior at a local high school was doing an independent study project for an art class. Part of the project involved etching glass with nitric acid. His art teacher told him to go to the science department to see if they had nitric acid he could use. The student asked the chemistry teacher, and the chemistry teacher told him it was in the chemical storeroom and that he should go help himself. The student brought out the large 2.37 liter bottle of nitric acid and under a fume hood started to dispense the acid. The chemistry teacher asked him a question, the student turned to reply, and the acid bottle spilled to the floor. The student's blue jeans were covered in nitric acid. The room did not have a safety shower, but did have a 5-gallon carboy of water. The student ran down to the boys' washroom and with cupped hands was having to put water on his jeans. The boy suffered third-degree burns to both legs and missed a large portion of his senior year due to his injuries. Medical expenses are over $60,000. His legs are disfigured and he lost out on a full-ride track scholarship to attend a large university. The chemistry teacher's opinion of the whole circumstance is that the student was a straight A student and should have known better. What went wrong? First of all, nitric acid does not etch glass. The activity was flawed. The chemical that etches glass is hydrofluoric acid, a chemical that probably should never be found in a high school science laboratory or art laboratory. The art teacher was not familiar with the project. This was an independent study project, and the art teacher should have known what the student was going to be getting into. The art teacher had no idea. As a result, the student was getting involved in an activity that no one knew anything about, which is danger. The art teacher sent him to the high school chemistry laboratory, and he asked him to ask the chemistry teacher, could he borrow some nitric acid? But there was no instruction or warning given to the student about the dangers of nitric acid. The chemistry teacher does not ask the student about what he's going to use the nitric acid for. He says, go help yourself, which is danger. The chemistry teacher didn't supervise the student in any way. The room had no safety shower or body drench. The boy had to run down to the boys' shower room to wash off the acid. Let me introduce to you Kelly Ryan. Kelly Ryan is a really good friend of mine, and he's a very, very experienced high school chemistry teacher who has gone on to get his law degree. And part of his law study involved safety in the high school chemistry laboratory. And what he's done is he's reviewed every case that went to the appellate court case level that is now case law for any science accident that occurs in the country. And there are 3 duties that Kelly has identified in this book. The first duty is that you must instruct and warn the students about all dangers. The second duty is that you must supervise these students at all times. And the third duty is that you must have a safe learning environment, which means you must have fire blankets, spill control, a safety shower. So what happened in this accident? Was this student at any time ever supervised by either the art teacher or the chemistry teacher? Absolutely not. This accident would not have happened if the chemistry teacher had been standing right here. What happened, folks, is that the student was smart enough to have goggles and aprons on. He was by the fume hood. He was starting to try to dispense the acid. The chemistry teacher asked him a question. He turned to reply because he's a very polite kid, and the acid bottle was caught by his arm and it tumbles to the floor, and now he has nitric acid on his shoes, socks, and pants. The room does not have a shower. He has to race to the boys' washroom. Was there ever a case where they warned and instructed the student on how to do this activity? None whatsoever. They didn't talk to him about being corrosive or the dangers of handling nitric acid. Last but not least, this room did not have any safety equipment in it. There was no safety shower or body drench. The boy had to run to the boys' washroom. The boy suffered third-degree burns to both legs and missed a large portion of his senior year due to his injuries. Medical expenses are over $60,000. $60,000. His legs are disfigured and he lost on a major track scholarship. His entire education was going to be paid for. Throughout this safety training program, I want you to remember one definition, the definition of negligence. If you can reasonably foresee the consequences of what you're about to do or not about to do, you're going to be held responsible. Let me repeat that. If you can reasonably foresee the consequences of what you're about to do or not about to do, you're going to be held responsible.